Today I'm providing an update on our Island County case. That's Hazelo, Abel, Peterson versus Island County and several elected officials there. If you haven't followed, this is our mask mandate case whereby our plaintiffs were required to wear masks to observe ballot counting in Island County during the 2024 presidential election. There's a challenge to the auditor's authority to implement the mask measure, and that's really the synopsis of the case. So if you've got questions on what happened before, go ahead and check out our website. We've got the pleadings up there. But we had quite a lengthy hearing, about an hour and a half, on 3 different motions, and some had kind of a couple of tangential issues. The first was a motion to strike pleadings and a request for tens of thousands of dollars of sanctions from the Island County Auditor. There was a motion to consolidate this case with a prior case, and there was a motion for preliminary injunction in opposition to dismiss the case and to strike some pleadings, as well as another motion for sanctions. So, with that, the first thing is the motion to strike. Our reply document on the preliminary injunction that had some stuff discussing the PA's prior social media, and the PA brought that, the prosecuting attorney for Allen County brought a motion to strike that pleading, seeking sanctions for having put that information. The judge did in fact strike that pleading, so you'll notice that we've removed that from our website, I believe. And so that pleading is, at least the materials within that pleading associated with the historical social media posts have been stricken from the record. I believe the pleading itself remains. We have yet to see the final order on that. So that was kind of a non-sexy issue, kind of got taken care of. The second one was the motion to consolidate. What happened was our 3 plaintiffs, Mr. Hazelo, Mr. Peterson, and Ms. Abel, had previously brought some sort of litigation. It was maybe had some procedural issues, and we sought to consolidate those pleadings into this case. And the judge determined that he would not consolidate the 2 cases, but he did keep our case live. What he did was he said, well, Mr. Peterson, you can continually do a pro se or self-represented litigation on the issue, but Mr. Hazelo and Ms. Abel, you can stay with the Silent Majority Foundation case. Really what the judge did was he kind of distinguished the bases of these cases. Ours has to do with the question of whether or not the auditor has the authority to implement a mask mandate or other health mandates. The Peterson issue, I think, the way it was addressed, it didn't have that specific procedural aspect. And so what the judge did is parse that out and said, hey, look, keep on your own, Mr. Peterson, but Mr. Hazelo, Ms. Abel, we can keep moving forward with this challenge to the auditor's authority. Also rolled into that motion to consolidate and some of the challenges there, and the prosecuting attorney for Island County sought to challenge the notion that we hadn't brought the Island County Canvassing Board as an entity, as a defendant, and stated that that was improper, that we failed to what's called plead an indispensable party. In other words, we failed to get one of the critical elements or one of the critical actors. We responded, and the judge agreed that by bringing each one of the 3 canvassing board members in their official capacity, it's duplicative to include the canvassing board. It's certainly doesn't hurt to have that extra party, but simultaneously the judge could have dismissed the canvassing board how we brought it that way. So he said, look, you've got all the actors, you've got them in their official capacity. It's really kind of whether or not you want to put that on paper. And so he denied that effort to dismiss the case based on that pleading an indispensable party or lack of. And so that really gets us to the meat of the argument. We were seeking what's called a preliminary injunction, which was to enjoin or stop any future mandates. Obviously, we couldn't do anything about November or even February 2025 special election where the auditor required that. But we also pointed to the fact that in February 2025 there was a special election and there was a mask mandate, and this notion that it's essentially going to continue indefinitely unless somebody puts a stop to it. Now, the judge kind of took two really interesting approaches to this in my mind. One, and it's not clear how much of this was kind of a devil's advocate approach and how much was where he lines up, because he did not give us an order yesterday. He said one will be forthcoming. Basically, what he said at one point was, well, listen, your challenge is that this is what's called an ultra vires act. In other words, you're challenging the auditor's authority to do this. So under those circumstances, I really don't know where she gets the authority. Again, this is my words, not his. And then he, in another turn of the cheek, basically said, well, Mr. Hatcher, our attorney, what if I just presume that this is a lawful act? Then what? Where's the harm? And it's we talked about the harm of forcing the masks, without any known value at this point. Talked about a couple of those things, and so really, I think what this case hinges on, from my read of the room from the judge, is really the fundamental question which we've raised at the core and center of this, which is whether or not the auditor has the authority to implement a health-based mandate. And it's really interesting some of the things that the judge caught on to. For example, he said, look, Mr. Hazelo and Ms. Abel signed in on this rule sheet, and it's attached to a declaration, but nowhere on the rule sheet is there anything about a mask mandate. That helps answer some of our questions. Certainly, had the rule been provided ahead of time, there's still the question as to whether or not the auditor has authority to make such a rule, whether or not her express authority to make rules associated with ballot processing includes health mandates. Nonetheless, the fact that she did not provide notice, I think, is certainly helpful to our case, and certainly the fact that the judge noted that and called attention to it was, again, I think, helpful to our case. So, bottom line is, the motion is strike. The materials associated with prosecuting attorney's prior social media was granted. So again, those elements are stricken from the record, and I believe we removed the pleadings from our website just to not cause confusion. Motion to consolidate was denied, and not having the canvassing board was not a fatal flaw, which really means we're hinging on the final request, which was whether or not the judge is going to preliminarily enjoin the auditor from making such a rule. And he said he'll issue a written opinion as soon as he can. That may be a week, maybe a couple weeks, maybe longer. But I anticipate over the next week or so getting something from the judge that will allow us to, either have an injunction issued, or, we'll have to figure out what to do from there. Notably, none of the sanctions request was approved, so it's been interesting watching how this plays out. The judge did have, pretty harsh tone on, again, the social media issues, as well as some of the sanctions requests. So he's a no-nonsense guy. I like that on the judge, and I think he's going to be really straightforward and cut and dry, and just get to the root of the issue and resolve it. So I'm looking forward to what's next, and we'll keep you posted. I know this is a longer video than normal, but a lot of moving parts. God bless. Thank you for your support. If you can continually support our cause, we certainly need it. Please get on, donate, and share the word. Thank you.